If everyone could please take their seats so we can get started. Hello, everyone. I hope everyone's enjoying their afternoon. My name is Chris Laughlin. I am a second-year law student here at the University of Colorado Law School, and I am symposium editor on the Colorado Technology Law Journal for this conference. It has been a really great pleasure working with Phil and Anna Nascazi and the rest of the Silicon Flatirons staff to help put this conference together. So I want to thank them for giving me this opportunity. I also want to thank all of the speakers for both being here and for being so good about getting me the information I need and working with me over the past several months. The Colorado Technology Law Journal is incredibly fortunate to have a strong connection with Silicon Flatirons. Conferences like these and the relationships we have with the tech industry leaders drive the content that's in our journal. I'm proud to say that several speakers, including the three presenters on the panel today, plan to submit articles to publish in the DBM Symposium edition of the journal that will be published next fall. As an editor on the journal next year, I'm excited to work with incoming editor-in-chief Jolie Denkinger and the rest of the executive board to bring that edition to publication. However, rather than wait to see what the journal is all about, you can, if you grab a copy of the most recent journal edition, you can check it out, or you can go online to ctlj.colorado.edu. With all of that out of the way, I'd like to go ahead and introduce the moderator of our next panel on competition policy. Jeff Blattner's career has more accomplishments than I can list in a short introduction, so I will try and highlight a few of them. Jeff is a former Supreme Court law clerk and current president of Legal Policy Solutions, a strategic consulting firm for public, private, and nonprofit entities. He is an expert in antitrust, having recently shared an award for his representation of Google in front of the FTC. As Deputy Assistant Attorney General and Special Counsel for the Antitrust Division of the Department of Justice, he supervised the Microsoft antitrust litigation. He also served as Senior Vice President of Public Policy and Special Counsel of XM Satellite Radio, where he managed all aspects of the merger with Sirius Satellite Radio. Jeff served as Senator Edward Kennedy's Chief Counsel and currently serves as an adjunct professor at the American University Washington College of Law. Thank you.
Thanks, Chris. Can everybody hear me? So this is the panel you've been waiting for because it's the last panel of the day. But it's also going to talk about the issues that all of our previous wonderful panels have reserved for us. And first, I do want to pay tribute and thanks to the folks at the Silicon Flatirons. I've known Phil since he was an exceptionally energetic young lawyer at the Department of Justice, working with Joel Klein as I did. And he's built a remarkable institution here and really deserves enormous, enormous credit for that. So we start this panel really where the last panel let up, and they set the stage perfectly. You heard David Clark talk about a network of networks, one that heretofore has been constructed, as he put it, shaped by business issues, subjected to negotiations that set the business terms. We also heard John Nectarline talk in great detail about both the structure of the network and about terminating access monopolies and about the terminating access monopoly problem. He reserved the case. Fair enough. Well, Sharon talked about the problem. So he reserved the case where there is a great deal of concentration at the ISP level. We heard Sharon talk about kind of what I would call a competitive utopia, the frictionless world she talked about, where there were lots of ISP choices, lots of content choices, and one might wonder what kind of regulation would be required in that perhaps hypothetical world. So with that, we have a wonderful panel. When I looked at this panel, I was reminded of advice that I unfortunately ignored from my chemistry professor in school who said, if you mix all these things together, they're going to auto-combust. And I have a feeling that hopefully we'll have a combustive conversation among all of these great experts. I'll introduce them very briefly. The presenters are going to go for 10 minutes each, and then the responses from the discussants will be 5 minutes each. Our three presenters are Commissioner Maureen Ohlhausen of the FTC, who has been at the FTC for several years now as a commissioner, had a very distinguished career in public service at the FTC, including heading the Office of Policy and Planning, was a partner at the Wilson Nauer firm in DC. Going second, although not second left to right here, is Fiona Morton, who's a professor of economics at Yale and was recently, 2012-2013, the economics deputy in the antitrust division. Then will come Jonathan Sallet, the general counsel of the FCC, who I guess has been busy lately. Prior to that, he served both in the Clinton administration, in the Commerce Department, as a law clerk for Justice Lewis Powell, and a partner most recently before joining the government at O'Melveny and Myers. Next, we'll have a veteran of the University of Colorado Law School and a veteran of the DC Circuit Court of Appeals. Judge Stephen Williams was appointed by President Reagan in 1986, took senior status in 2001, and continues to be an extraordinarily productive member of the bench and of the law. And then finally, last but not least, Gene Kimmelman, currently president of Public Knowledge. Before that, chief counsel of the Antitrust Division in the Justice Department. Before that, long ago, chief counsel to the Antitrust Subcommittee under Senator Metzenbaum. So with that, Maureen, take it from me.
Thanks. Well, I don't have any slides, but I'll just talk a little extemporaneously about competition law and what are the factors that make a successful agency in this space. But first, I do want to give the disclaimer. If I had one slide, it would be John's slide for the disclaimer. These views are just my own, not those of the Federal Trade Commission. I do also want to mention that I speak for the I don't speak for the FTC, but we are a very wide-awake agency that I want to draw Gene's attention to because we've been very active on the competition policy front and on the consumer protection front. But today I really want to talk about competition policy. So I'm a student of Bill Kovacic. He was one of my professors at the George Mason University School of Law. He's spoken many times about agency functioning, factors for agency success. He's spoken at Silicon Flatirons about this topic. And my talk today draws on the principles that he's developed in this area. And he wrote an article, Bill, with Professor David Hyman, that looked at what are the kinds of factors that go into making a successful agency, and particularly in the competition space. And he identified three of the most important factors as consistent political support, policy coherence, and the capacity and capability to handle the agency's mission. And by these metrics, I think the FTC has actually been generally successful, particularly in the past 20 years. The FTC's bipartisan design, I think, really helped us with political support. Both parties always have a voice in the agency's actions. And this is solidified with things like our voting rules. For example, the commissioners have a certain amount of time to consider matters and to vote on them, and we can't be forced to vote until a majority forms on a particular matter, and then we have a certain amount of time past that. Any commissioner can make a motion on any matter at any time. It's very rare that somebody might take over that function, and traditionally the bureaus move things forward and the chair kind of controls the agenda. But there is always that possible fallback that if three commissioners, or a majority, if it was smaller than the typical 5 commissioners, had decided that a certain motion or certain matter needed to be addressed in a certain way, that they could do that. The other one of the issues that we have at the FTC is We don't delegate very much to the staff. They may do investigations, but we oversee them. We have to vote on compulsory process. We vote on settlements. We vote on a very wide variety of things. I do think that this bipartisan design has allowed the agency over many years to have true policy coherence. We've been able to do long-term competition policy over a variety of different commissioner makeups, different political party leadership, different administrations. I think this is really paying off in the antitrust field. For example, we've done a lot of work on the state action doctrine, and this is the idea that a state can kind of give shelter to what is otherwise private anti-competitive conduct by saying, well, maybe this is kind of the state, covering this. And we've had several successful challenges to this type of activity to make the antitrust laws better. And we've done this through Democratic administrations, Republican administrations. We've had 2 cases before the Supreme Court. We won unanimously in one called Phoebe Putney. We have another case on the state action doctrine that was argued in the Supreme Court just this past fall. And so I think this is really, this kind of policy consistency and coherence has paid off. I think also the capacity that we have at the FTC, we've built our capacity. We are primarily a law enforcement agency. We do investigations, we bring enforcement actions, we do a little bit of rulemaking, we have the authority to do it, but traditionally we mainly are an enforcement agency, but we also have an important policy-making function. Jeff mentioned I used to be the head of the Office of Policy Planning at the Federal Trade Commission. That was one of the important functions that we played there, that I played there, was helping to coordinate what kind of research do we need to do to understand what competition problems and consumer protection problems are coming down the road. So the FCC has some of the same elements for success as the FTC. It's a similarly designed bipartisan organization. But I do think it faces some challenges in these 3 areas: consistent political support, policy coherence, and capability to carry out its mission, particularly in the area of broadband. So it's no surprise to anyone here to say that it hasn't gotten a lot of political consistency or general support in the area of how it's treated broadband. There's been a lot of controversy in this area. It's lost several cases. In the D.C. Circuit, there have been challenges, and the most recent proposal certainly has created, I wouldn't say it's created a bipartisan consensus around it. It's also shifted over the years. Its classification of broadband has shifted from being an information service to now we're hearing it's going to be proposed to be treated as a Title II service. And so I think this creates some challenges for policy coherence across administrations. I think it creates, depending on the breadth of the reclassification, it could create some challenges for the FCC to carry out this mission effectively. It sounds like there may be a lot of new responsibilities for the agency, and of course it would need to have the tools to address those. Chairman Wheeler's new proposal to reclassify and then forbear, I don't think it would resolve these design issues and may actually exacerbate them. In particular, I think it raises challenges to have the policy consistency. If you have a strong opposition from one party, you kind of wonder how that will fare in the future. So my thinking in this area, when you have such an amount of change going on, when you've got parties who are viewing these issues very, very differently, I would recommend that one of the strengths that we have in our system is for Congress to step in and to start to resolve some of these issues, to reach those kind of compromises, so that you can have a solution that's more enduring over time, something where a change in administration, a change in leadership at an agency would have less of an impact than if you, over the long term, if you have Congress come in and make a decision. So, one area that I was talking about, the intern my former intern who picked me up at the airport, Jolie, was mentioning when the FTC did our do not call rule, right? An example of a federal program that is widely seen as being very effective. And we were talking about what were some of the factors that went into making the do not call rule effective, because it was a pretty big challenge for the Federal Trade Commission. We did create bipartisan consensus within the FTC for it. We established a lot of in-house capability to make it happen. It was actually a big technological challenge to get everybody signed up for it. But what people forget is that it was actually challenged in the courts, and we were being told that we didn't have the jurisdiction to do this. And so what the FTC was able to do was to go to Congress very quickly and get our jurisdiction clarified very quickly, because we had the support in Congress for what we were doing. So I think that's a good lesson to kind of, right now everyone looks back and says, oh, of course it was easy, everybody liked the do not call rule, but the amount of time and effort that went into creating a program that was effective and sustainable, and that when it was challenged, Congress came in and backed us up, I think gives some lessons for how to move forward in an area to have a new government program, a new government approach that will endure over time. So with that, I'll stop, and I look forward to our discussion.
So,
Okay, hello everybody, and thanks very much for the invitation to come and speak. It's a pleasure. I'm the token economist on the panel, so I'll try to say some things that are appropriately advanced for a law audience, but not too hard. How are we doing with the slides?
Can we have your slides pulled up, please?
This always happens at high-tech conferences. Oh, there we go. Okay, so Commissioner Ohlhausen raised the question, can antitrust enforcement achieve the same beneficial outcomes as industry regulation? And I'll take the case of cable broadband, since that's what we're talking about today. And I think the answer is no, but it's a very interesting question, because let's imagine that we're contrasting the competition authority with a kind of an American-style regulator. And by that I mean, let's leave aside, if we were pretended we were a European-style regulator, maybe we would care about employment or the market share of the government-owned firm or something like that. So let's leave those kinds of concerns aside and take the case of a regulator who's maximizing consumer welfare. Okay? So a regulator is maximizing consumer welfare, and a competition authority are really trying to do the same thing, maximize consumer welfare. And you might imagine that the best way to do that is to promote competition. And so maybe if we've given our competition authority the right tools, then all the regulator has to do is match that. And so then really the two would be interchangeable. Okay? So that's the question, but I think that that's not true. So the first point, I think, is sort of straightforward. Suppose that you've got a monopolist in your market. Well, this monopolist is not violating any of the competition laws that we have in the United States. So it's not violating the Sherman Act, because there isn't anyone else in the market with whom to collude. It's not violating Section 2 because it's already a monopolist. It doesn't have to engage in monopolization. And it's not violating the Clayton Act because there's nobody to merge with, okay? So the antitrust authority just doesn't have any scope to do anything about this monopolist, and yet the monopolist is able to provide a high price, set a low quantity, charge a low quality, set a low quality, and not be violating any competition law, okay? So a DOJ FTC actor in that environment is not going to be able to improve consumer welfare. Unless, for instance, they were to, well, swing in and break them up. So the alternative is the antitrust authority could challenge the monopolist. We could have an AT&T kind of situation where the authority says, okay, I'm taking over from the regulator, and what I'm going to do is, break you up and force access or something. Such an action would create competition, and by creating competition, then give the antitrust authority something to do. Okay? And you could imagine an analogy to choosing a long-distance phone company. Which video provider does the consumer want to put on the broadband wire? Okay, That might be something that that would create competition that the enforcement authority could do if they felt like, you know, destroying the monopoly power that they're given. But that's a pretty strong action by a competition authority. That's not a tweak around the edge. That's a wholesale, you know, blowing up of the market structure that they've been handed. Okay, so that's a kind of a, I don't think that's really the option that was envisioned here, option on the table. So the first difference between the regulator and the antitrust authority is when the market structure is monopoly. Okay, there's nothing the antitrust authority can do about that. Now, we have to ask the question, are we in a setting where that's true? Is broadband a monopoly? Many will say that cable broadband faces fierce competition from mobile broadband, satellite services, DSL, fiber overbuilding. Others will note that there are limitations of each of these technologies in providing fast broadband. Mobile is still developing, it's pretty expensive. DSL is too slow. Satellite lacks the capability to go both ways. Overbuilding, there's a limited number of households in America, I think 75% is the number I've heard lately, that would have a choice of a cable, you know, a fast cable coming into their house. So if most consumers, if 75% of consumers have 1 or 0 fast fiber optic cables into their house, then I think, you know, as a regulator, you might be worried about that. Now let me remind you about why regulation is so controversial. Okay, it's hard to do. This year, those of you who follow the economics world even a little bit might have known that French professor, Jean Tirole, won the Nobel Prize. And he won it really primarily for his work in the area of the economics of regulation. And the reason this is hard is, of course, if there's vigorous competition, you don't need to regulate. Why do we have regulated firms? We have regulated firms that have market power because they're not going to produce the efficient price and the efficient quantity all by themselves. And what Tirole did that's so good is that he built up the economics literature by putting in a bunch of really real-world assumptions that had been left out in previous work. So, for example, the regulator doesn't know as much as the firm knows. There's asymmetric information about demand or costs. Okay. The firm has to break even. We can't subsidize, we can't have the government building all fiber optic cables and then somehow taxing consumers to pay for that. We're going to not have a political economy that wants to do it that way. We're going to make the firm pay for itself. The regulator has trouble committing to policies over time. Today's regulator does something and the firm is suspicious that after the next election or a change of leadership at the agency, there's going to be a different policy. These kinds of problems are actually pretty difficult to handle, but you can show that there are best policies for the regulator to use in these kinds of circumstances. Let me just highlight 2 of them and then I'll get back to the main point of the talk. So costs. How large are a firm's marginal costs? What about the cost of investment in, say, new capacity? What about joint costs? If I build a fiber optic cable and it's used for 2 or 3 or 4 different purposes, how much does each one of those cost? Okay. What rate of return am I going to give this regulated firm? What kind of risk am I assuming that the regulated firm is bearing, and how would that relate to the rate of return? Okay. So if the regulator is going to allow prices that cover costs, like we often do in electricity or other energy contexts, then this lack of information is a huge problem. Okay. Another asymmetry that we often see in this setting is effort, what economists call effort. That's really unseen actions that managers take that affect performance. A manager could actually exert effort or not, could choose travel regulations that minimize cost or not, could take decisions with great care, could hire subcontractors that are not their friends, but somebody who's efficient. Okay, there's all sorts of things that a manager can do that are unseen by the regulator and affect the performance of the firm. So if a manager's behavior can't be fully observed, and yet it affects profits, then the lack of information is a problem. So what does a regulator do under these situations? The regulator sets up incentives that induce effort and sets up incentives to minimize cost. Okay. Now, does the regulator get a perfectly competitive outcome? No, you can't. And the reason you can't is because of the asymmetric information. If you, the firm, know more about your cost than I know, I can set up a scheme to induce you to do something, but I can't get you all the way to the perfectly competitive outcome because you know too much more than I know. So will regulation naturally create errors? Yes, it will, because it's imperfectly imitating competitive outcomes. But one thing I think we have to remember is we have to compare this to a lack of regulation. Today I've heard a lot of people say, well, you know, regulation's so terrible and the government's going to go around claiming that there's monopolies everywhere so they can regulate. I feel like the monopoly is a little bit like the measles, okay? Here in America, we really don't have them very much. And so I think it's easy to forget that monopolies are actually really terrible. They charge high prices, they minimize quantity, they provide terrible quality. And the United States has very good competition authorities, and they stop us from being subjected to monopolies very often, and the rest of them are regulated. Okay? So we don't actually experience monopoly power very much. And so I think it's very easy to say, oh, it would be fine if the regulator backed off and we let the monopoly firm do its thing and control innovation and choose the technologies we're all going to have next and provide the service it feels like providing. But I think that that's a mistake, because though that is not going to be a good outcome for consumers. So I think with certainty we get the monopoly outcome if we leave the monopolist alone, and there is some chance of getting something better if we try to regulate the monopolist. Okay. The second reason that I think you're not going to get the same answer if you replace the regulator with the antitrust authority is that the regulator has a lot more tools. The regulator can decide things like rate of return, technology choice, interconnection rules, shared cost rules, access, okay? Stuff that is not really envisioned in the Sherman Act all the time. And there are going to be statutes that permit regulation of these dimensions using some kind of formal process. And there's often wide discretion to fix outcomes that are not considered to be in the public interest, okay? Now, why is that important? Well, the antitrust laws only cover certain kinds of behavior. And in an imperfectly competitive environment, society may benefit from restricting or promoting certain actions of the regulated firm. So let me give you an example of what I mean. And this is not, maybe I'll come back to innovation. Yeah, I want to do this first. So consider the following. And I have nothing to do with Netflix, so I'm making up the statements on this slide, but they're roughly out of the newspaper, so they shouldn't be too bad. Consider the structure of the contract between a content provider and a cable system. Let's take the one in the newspaper, Netflix and Comcast, okay? Suppose that right now the structure of the contract is Netflix pays a lump sum for favorable speeds from Comcast. What does that do to Netflix costs? They rise. Okay, but not all of Netflix consumers are Comcast subscribers. So Netflix costs have gone up because of a subset of consumers. Comcast is getting a lump of money for speeds to be high, but not all of Comcast customers subscribe to Netflix. So what kind of incentive do they have to build infrastructure when some fraction of their guys subscribe to Netflix and some don't? Okay, so you could imagine that this kind of contracting doesn't maximize the incentive to build capacity correctly and doesn't maximize the incentive for the consumer to judiciously choose how fast she wants her stuff to arrive. Okay? For example, the regulator might say, I'm going to outlaw that kind of contract and I'm going to allow Fiona to contract with Comcast for Netflix to arrive at 25 megabits a second. Okay, because that will allow Comcast to sell speed, and if I want it, then that's a favorable investment opportunity. And that will not raise the price of Netflix's operation, but it will load my desire for speed onto my bill. Okay? So we could say, so this is not a competition problem. The first contract is not a violation of the Sherman Act. It's not a violation of the Clayton Act. It's not a competition issue, but it's an efficiency issue. You might say we'd prefer this other kind of contract because that's going to be better for consumers, better for social welfare. Okay? Yeah, I'll finish up in just a second. So I think that this kind of issue highlights the problem of innovation. Protecting and stimulating innovation is a setting of real interest and importance. And it's important for comparing antitrust and regulation also, because Innovation's often not a merger problem or a monopolization problem or a collusion problem, and the antitrust authority can't mandate the direction of innovation or its amount, but this may have a large effect on social welfare. Okay? If the status quo isn't favorable to innovation, then we might want the regulator to do something about that. So in the example I just gave you, entry under the lump sum transfer of money from Netflix to Comcast, the entrant has to have a lump sum to give in order to get high speeds for its stuff. What if I'm Twitch and I have not now we have 100 million customers of Twitch, but let's say on the first day there weren't very many, where does that lump of money come from? On the other hand, if the people who love Twitch can say to their broadband provider, I want this to arrive at 25 megabits, then the entry barrier for the new entrant is much reduced. Okay, they just have to have consumers who want them. They don't have to have a huge amount of consumers and a lot of money to pay for access. Okay, so we see from this example that the terms on which contracts are written and the parties permitted to write them might affect innovation, investment incentives, prices, and the antitrust authority might not be able to do anything about that, but the regulator often can. Okay, so that concludes my remarks.
Thank you. Just for everyone's understanding, during the question and answer period, we'll come back to the question of whether there are strong antitrust tools to address the competition issues related to the broadband market structure. But before we do that, we'll turn to John Sallet for a description of the FCC's regulatory initiative and role in competition policy.
Thank you, Jeff. I'm struck by a mathematical calculation, which is, if I understand it, in the last two panels, we've heard from two general counsels of two federal regulatory agencies which share two of the same three letters in their name. But the general counsel shares three of the same three letters because, as everybody in this room should know by now, John is spelled without an H. So when I get up to disclaim the fact that this is not an official governmental view, I was inclined to see if I could actually say these are the personal views of John Nectarline. But I won't. Competition policy rightly starts with antitrust principles and reasoning. We've learned a lot from modern antitrust about consumer welfare, efficiencies, market power, entry conditions. But what I want to talk about for a minute this afternoon is my belief that we shouldn't always end with antitrust. In other words, we shouldn't believe that every policy that serves competition is necessarily captured by the four corners of antitrust theory. An obvious example is spectrum. Spectrum is a critical input into the provision of wireless services, such as in the incentive auction that the FCC is planning now. In providing spectrum, in providing that auction, the FCC provides an input into competition. And in structuring that auction, the Commission set rules creating a limited reserve of low-band spectrum for bidders who are not dominant in the space. The goal, obviously, is to incent competition and to prevent dominance in spectrum holdings that could turn into dominance in consumer markets. So ensuring access to an input in this way is important. But the FCC appropriately and directly looks to how markets are operating, consumer markets. And it does so with a broader aperture than do antitrust statutes like the Sherman Act, which look back in time to see whether violations have in the past occurred. To put it another way, the Commission looks to the future of competition. Now, that's not unknown in the antitrust laws, right? Think of the way merger reviews operate under Section 7 of the Clayton Act, where the goal of an antitrust agency is to make a decision as to whether a proposed transaction may substantially lessen competition or tend to create a monopoly. Note the future tense. As the Supreme Court explained in its Brown-Shue decision, and I'm quoting, Congress used the words may be substantially to lessen competition to indicate that its concern was with probabilities, not certainties. So looking to the future is about trying to assess those probabilities. It's especially important, I think, in terms of innovation. Fiona's comments are important here, right? It's it's important, I believe, to consider whether innovation, future innovation, may be stunted by current market conditions. The FCC's Carter phone decision is a good historic example of trying to look into the future. That decision, as everybody here knows, and if you don't know, I guess you haven't taken Phil's course yet, but as everybody here should know, let me say, found that innovation and competition would be best served if non-harmful devices could be attached to the then monopoly network. A more recent example is the proceeding in which we're requesting comment on the current definition of an MVPD. This gets a little technical, but the core of the question concerns the current market for video competition. We're seeing over-the-top video like Netflix supplying long-term video programming that consumers may prefer to the video programming of broadband ISPs over whose connections Netflix travels. We've seen a lot in the last few months. Dish's new Sling package of channels, Sony's plan for a package of its own, CBS offering streaming, HBO planning to do so. So here's the prospect for both innovation, especially in business models, and competition. Competition is shaped by the relatively few choices that most American households have for high-speed fixed broadband connections. You've heard the numbers before, which are given the way, by the way, the data is cut at the FCC, with a significant majority of American households having 0 or 1 choices to broadband of 25 megs down, 3 up. So the Commission has begun an NPRM that proposes to extend certain programming rights to over-the-top providers that are providing multiple channels of video programming. The question, simply put, is whether by choosing a technology-neutral definition of what is an MVPD, the Commission can remove a potential stumbling block to more competition. Another point, competition in this context has substantive meaning beyond traditional economics. Free expression is a good example. I've long been attracted to the idea of competition in the marketplace of ideas. That's the phrase that Justice Holmes used in his famous dissent in United States versus Abrams. Free expression is always an important individual right, but the marketplace of ideas captures an additional 2 ideas. First, that the antidote to, quote, bad speech is more speech. We believe in the instructive power of debate in civil discourse. And second, that the importance of speech is not just to the speaker, but as in a commercial market, to the consumer of speech as well. The FCC has traditionally worked to ensure a diversity of information sources, consider our media ownership rules, and I view this as a form of competition policy as well. The process we use to put competition policy in place is also important. The question's been raised about ex-ante rules. I believe that those rules, rules of the road, can boost competition if they're carefully devised and applied. Consider, for example, the Commission's famous computer inquiries, particularly Computer Inquiries 2, which in the 80s separated the monopoly in telecommunications transmission from the nascent market in data applications and devices. That action by the Commission, those actions, there were multiple proceedings, helped ensure that consumers in the 90s could plug in a device to the telephone network and use it to go wherever they wanted to on the internet. Freedom that both served consumers and that, of course, unleashed demand, market demand for the first generation of internet services. Now, let's fast forward to the present, where there's also a discussion about what kind of rules should be in place. Some of you may have heard that last week Chairman Wheeler made a proposal on open internet rules. I'm not going to talk about what's in that draft. It's in front of the Commission. It's going to be voted on February 26th. But I do want to talk about the intellectual framework of the discussion. And it's one that has endured for over a decade. Since Michael Powell came to this place in 2004 and talked about the need for an open internet, since the Commission adopted its first internet policy in 2005, through both Democratic and Republican chairmen, there's been a simple belief that the open internet must remain open. In 2014, right before last year's conference, the D.C. Circuit issued its opinion in Verizon versus FCC, considering the FCC's 2010 rules. It's worth understanding in the context of competition policy how the court reached the decision upholding, in this part of the decision, the Commission's notion that its rules reasonably would serve an open internet and broadband deployment. So the court reasoned in this way. First, that the internet is a general purpose technology that, like the light bulb, the court said, can create a need for infrastructure development that complements and further drives the development of the initial innovation and ultimately the growth of the economy as a whole. The court used streaming video as an illustration. Higher speed internet connections stimulating the development of streaming video that in turn encourages broadband providers to increase speeds, the so-called virtuous circle. Second, the court said, and I quote, continued innovation at the edge depends on low barriers to innovation and entry by edge providers, and thus restrictions on edge providers' ability to reach end users reduce the rate of innovation. And this sentence was swiftly followed by a citation to an article written by Phil Weiser and Joe Farrell. Third, the court held that the Commission had adequately explained that, quote, broadband providers represent a threat to internet openness and could act in ways that would ultimately inhibit the speeds and extent of future broadband deployment. In other words, the court found, or the court upheld, the Commission's judgment that broadband providers have both the incentive and the ability to interpose themselves between consumers and edge providers. Fourth, the Commission, the court concluded, need not find, quote, market power in order to act. Why? Because, the court explained, quote, broadband providers' ability to impose restrictions on edge providers does not depend on their benefiting from the sort of market concentration that would enable them to impose substantial price increases on end users, quote. And we all know that one of the tests for increased concentration is the ability to unilaterally raise prices. Rather, the court said the exercise of such power simply depends on end users not being fully responsive to the imposition of such restrictions. The point I want to make is that this discussion is about competition, even if it is not about the traditional application of traditional antitrust laws. If an ISP blocks a streaming video company, the impact is adverse to consumers. The impact is not just on limited competition among edge providers, whose ability to deliver innovation to consumers is curtailed, but the action can also suppress consumer demand for more and better broadband, also harming innovation in networks. So this reasoning from the D.C. Circuit, I think, is instructive of the point. A way in which rules by the Commission, sensibly applied, carefully devised, but looking to competition in a broader scope than perhaps an application of, say, the Sherman Act would allow, can be understood to be a sensible application of competition policy that serves consumer welfare, boosts competition, and also advances non-economic interests like, for example, the ability to speak one's mind. Thank you.
Judge Williams?
Well, we've had 3 speakers, 2 advocates of industry-specific regulation, one rather gentle advocate of pure competition policy. But one thing, no speaker on either side has mentioned what I thought was the elephant in the room, and that is the generally understood, I had thought it, greater susceptibility to capture of an industry-specific regulatory body, for the obvious reason that if you have an industry-specific regulator, you have a target for which interests can zero in, whereas if you have an across-the-board antitrust enforcer, no single industry is likely to have anything remotely like the same incentives. So it raises, I think that proposition is very hard to dispute, but I think it raises other questions, which, since nobody talked about the first question, they didn't talk about the second question, which is who actually are going to be the winners in this? The standard notion is it's the regulatees who capture the regulator. I think it seems to me it's much more complicated. I mean, we have two great examples which are actually brought to mind by the current discussion of the application of Title II, the Interstate Commerce Act of 1887 and the Telecom Act of 1934. In the case of Interstate Commerce Act, the story on that, told at least by the revisionist historians of the 60s, was that that was captured by the railroads because they wanted to capture Congress initially. They wanted to eliminate competition. Well, how did it work out? It, in effect, drove the railroads, in many cases, to bankruptcy. It essentially decimated the industry. The industry was rescued ultimately by the 4 R's Act and by the Staggers Act. But if that was regulatory capture, it was a real disaster from the point of view of the primary regulatee industry. On the other hand, we have the FCC and AT&T, its principal regulatee. And this is a great conference in one day, and we had 2 references to Carterphone already. And somebody said how wonderful it was to be in a conference where just walking down the hallway, you heard people talking about Carterphone. Well, it is great. But you should remember, and Carterphone, as someone here summarized, Jonathan, essentially said that the commission would not stop a coordinate product being sold unless there was actually some harm to the technical harm to the protected regulatee, AT&T. Okay, but that Carterphone comes after the FCC's resolute efforts to protect AT&T from Hushaphone. Hushaphone, a device which enabled people to, it's a little plastic thing or rubber thing you put by your ear so you could hear better. And AT&T was bent all out of shape by that. And the FCC followed along, happy to suppress it at the behest of AT&T. And they were only interrupted, I have to confess, by my predecessors on the DC Circuit. Meanwhile, the commission was working on more serious competition, that is preventing MCI from providing long-distance service. And the commission and AT&T played a long game on that. And ultimately, again, I have to say, with a little nudge, a couple of important nudges from the DC Circuit, gave in, and that really was the beginning of the end for the marvelous partnership that had been worked out between the commission and AT&T. Then you go back to Carterphone. Why did you have a commission passing on such a thing at all? When you think about that, it's kind of peculiar. Why was that necessary? So I asked the panelists, really, and this, I gave a lecture there, but now I'm really asking for information, for speculation. Which of the interests that will prevail in a strong system of industry-specific regulation, I mean, in this particular industry. Now, in the press, there is incessant reiteration of the proposition that this sort of regulation is needed to protect the small innovator. And we have echoes of that in Fiona's talk. I just wondered about that. If I heard him correctly, David Clark said that basically it's the health of the intermediate layer in terms of negotiating with the ISPs that is going to be the most important thing for the small innovator in getting access, and that sounded extremely plausible to me. And I guess I would ask, just as a matter of history, wouldn't be prediction, are there some famous cases of small innovative companies getting huge legs up by virtue of going to regulators? I don't know. We don't see those cases on the DC Circuit. Maybe they're lying around all the time, but interesting. Let me, a couple more minutes, or 1 minute? Two, okay.
Didn't hear him off.
A couple of things about Jonathan's talk. First, I want to say that his description of my colleague David Tatel's opinion seems to me corresponds far better with my recollection of that opinion than anything I've read in the paper about it. In the paper, it's described as something that prescribed almost anything that the FCC might do unless it went straight to Title II. Like Jonathan, I read it rather differently. Jonathan gave a paper here that I heard him deliver at the time, and I don't think I fully understood it, and I'm sure I don't understand it now, but I have gone back to SSRN to read the whole position, in which he talks of the broadband value circle. And circle is the key metaphor in that, and it's a depiction of the industry circled with the consumer at the center and all these different industries, in fact, trying to capture as much of the consumer's attention as they can. And it's the absolute opposite of the notion that you tidily divide an industry or a set of industries into upstream and downstream, and you watch the little product go downstream until it finally arrives at the customer. And he says in that, businesses in such a circle know instinctively that competition is coming at them from all directions. And I guess it's a natural question to have if that's an accurate description of sort of full internet space, to use the favorite metaphor, is a system of regulation dating from 1887, where you did have, so it was much easier to depict as a stream of commerce rather than a circle of commerce. Is that well designed for it? I've probably gone over my time, but I have other things to say, given a chance.
That chance will come. Gene?
Thank you. Thank you to Silicon Flatirons again for inviting me. And again, Phil Weiser puts on a fabulous conference. Congratulations to you, Phil. As I listened to everyone in this panel, but also going back through the day, something I'd like to raise with all of you to think about is it's my impression that what we are asking for, whether we're talking about the antitrust laws, whether we're talking about broader competition policy, and particularly if we're talking about the Communications Act, what we are asking for from these laws is quite remarkable, from healthcare to education to freedom of expression to all the competition issues that Judge Williams just mentioned, which have been more the traditional conversation in communications policy. Just think about it. It's an enormous responsibility we're putting on this body of law. And I think what it means to me is that this is not a dichotomous discussion between antitrust and FCC. In my mind, it's really a question of how you harmonize antitrust and communications policy. What comes to mind to me as I listen to Commissioner Ohlhausen talk about her perspective from the FTC on the FCC, it didn't sound all that kind, but when I was in the antitrust division, I recall from the very beginning, coming in and working for Christine Varney, very similar attitudes from economists about the FCC's economists, or lawyers about the FCC's lawyers and the way they did what they did. It wasn't quite the same way that Commissioner Ohlhausen described it, but similar kind of attitude. And what Christine Varney did was, as we had our first intersection with the FCC, she asked for a convening with Chairman Janikowski of front office people and high-level FCC officials, and they agreed upon a set of brown bags. All the economists would have weekly brown bags. The lawyers would have weekly brown bags. And they would discuss the differences between the jurisdiction and some of the matters before them, and not just matters before them, but matters where the Department of Justice might have views about competition policy that would be valuable to the FCC and vice versa. And so there was this enormous effort, and I hope it goes on to this day. I don't know that it does. But it was a real effort to bring these two bodies of law and agencies together in a more harmonized way. So I have to say, that is my hope of how this all can work together. But a few things jumped out at me. I was a bit confused, Commissioner Ohlhausen, when you talked about policy coherence. I totally get it for do not call. I saw the same at the FCC for the original wireless rules, and where there was inadequacy in the law, the FCC went back to Congress and got the law changed. The FTC did the same. But I'm wondering, what about the charged issues? Wouldn't broadband be something similar to a debate about Section 5 of the Federal Trade Commission Act? Fairness? Would that be a bit charged if we talked about the little bit of rulemaking power you described, the FTC being applied under Section 5 today in the broadband environment? My sense is it could be just as acrimonious and contentious as some of the things we've seen at the FCC. So I'm not sure there's really that much difference in these agencies. I think Judge Williams makes a very, very important point about capture. And all those historical facts, quite true, and things that reflect doubts about the FCC's ability early on to deal with innovation and market entry, I think Congress was fully aware of. And when it passed the 1996 Act, with broad bipartisan support, it updated the 34 Act, and it gave the FCC broad powers to prevent discrimination, to actually promote competition, as both Fiona and John Sallet indicated, were beyond what some of the antitrust tools are. And I think most importantly, it gave the FCC power to evolve some of its definitions based on market conditions, which is exactly what it has been doing. And I will take universal service as an example, where is it plain old telephone service? Is it a landline? The world has changed dramatically. The FCC is dealing with that, I think, appropriately. And it's exactly the example of where you want regulatory flexibility to deal with market changes so Congress does not have to come back and intervene. And we know they don't do it very often and not always so well. So my perspective is that antitrust, which we haven't discussed at great length, does some very, very important things, is critical, is essential, but is certainly not sufficient to promote competition or to have a robust, comprehensive competition policy. And we must keep in mind that it is in the context of not just competition that Congress has directed the FCC to act. As John Sallet said, it's diversity of information, it's promoting entry, it's promoting investment, it's promoting affordable access to services. These are far beyond antitrust and far beyond straightforward competition analysis. So if we're to follow what Congress has actually directed the agency to do, I think the best thing is to make sure that what the FCC does in this space is consistent with antitrust enforcement, is harmonized with antitrust practices, and it sounds to me like there is an effort to do that. I hope that's where they're going.
So let's sort of step off from where Jean ended, and I'd like to give Maureen an opportunity to tell us whether Fiona is too pessimistic about antitrust enforcement, and then I'm going to ask John to tell us whether Judge Williams is too pessimistic about agency regulation.
Okay, thank you. So I do think one of the important questions to ask as we're thinking about antitrust policy here, Fiona talked about monopolies, but one might ask, why is there a monopoly to begin with? Why is there a monopoly in this space to begin with? Sometimes there is a monopoly, or it should be that there's a monopoly, that they gained that monopoly through providing a good service to consumers at a good price, and so they gained the market share fairly. If they gained it through anti-competitive behavior, one would hope that the antitrust laws should have stepped in, earlier to stop that. But one of the other ways monopolies are extended is really through government permission or government granting monopolies, or sometimes turning a blind eye to them. And I think that Judge Williams was talking about the very cozy relationship between the FCC and the AT&T previously. And so what do we do when there is a monopoly? I don't think that we are without tools as antitrust enforcers. There's Section 2 of the Sherman Act. We look at monopoly maintenance. We don't forget AT&T was broken up through the antitrust laws. I think that was very important. We can talk about Carter Phone. I think that was important, but I would say the breakup of AT&T was quite a bit, maybe equally, if not more important, an event. We have the Microsoft case, right? That's a single firm case. We're in Colorado. I have to mention Aspen Skiing, Lorraine Journal, Otter Tail. The list goes on and on. We do have the tools in antitrust to address these things. Some of the behaviors Fiona was talking about, they may not be reachable under the antitrust laws. They're only reachable if they're anti-competitive. Right? If those are anti-competitive actions that companies are taking, we should be able to reach them under the antitrust laws. If they're not anti-competitive, one questions why one needs to reach them. I think that talking about other values, I understand that. I understand that that's one of the jobs that the FCC has been given. You have a public interest standard that we don't have under the antitrust laws. But I do think we have seen quite an explosion in viewpoints. I see that as a very expanded market, actually, moving away from having the three big networks that kind of controlled a lot of the information flow. I think what we've seen in the past, 20 or more years is quite a growth from that. We have people are live tweeting at this event. We have blogs, YouTube, and that goes on and on. I did also want to address Jean's point. Actually, Jean, I think we're in agreement. You're talking about if the FTC tried to move forward using Section 5 expansively, that would be acrimonious. And I agree with you. And I think that's the reason why the FTC shouldn't try to move forward to use Section 5 expansively unless there's a commission consensus on it, because I don't think it would be enduring, and I don't think it would be very good for the agency. So I think we actually are in agreement with that point. So I think that I'll stop.
So just turning to John, so markets get concentrated, as Maureen was saying. Firms obtain market power really through three means, right? One is skill, foresight, and industry, in the words of the antitrust literature.
Industry.
And industry, right? So, you do a good job, as Microsoft was held to have done in building its operating system monopoly prior to our case. That's legal. Okay, then the other end of the spectrum, as it were, is through illegal acts. But there's the middle case, which is through mergers. And Section 7 itself is a very powerful tool. Antitrust regulators and, in this case, the FCC, take a strong look at whether a merger will increase the market power of a firm beyond the market power that it has going in. And so, one of the questions as we turn to John is whether the need for regulation itself may reflect less than perfect merger policy in the past.
I have no idea. I'm not familiar with less than perfect merger policy in the past in a manner that would allow me to answer the question. So maybe I'll go to the other question you're going to ask me.
You pick that one.
First of all, Judge Williams, I very much appreciate your taking the time to read my Broadband Values Circle paper, which I appreciate, and which Phil Weiser was a great help with and was published here thereafter. Let me talk for a minute if I could, to Judge Williams' point about the question of regulatory capture, which I think is an important one. I think the hush phone example is exactly the right example, as Judge Williams gives it, of a time when the FCC saw its interest as aligned with a particular company, actually. And I don't know if you knew when I was a young lawyer a long time ago, I had a law partner, Jack Miller, who argued the Husherphone case in the D.C. Circuit in the 1950s, and he loved that case, right? It was a fabulous case because he rightly convinced the D.C. Circuit that eliminating competition in this way served no one's interests and was not necessary.
Except AT&T's.
Was in no one's interest except AT&T's, that's right. And that was not synonymous with the public interest. Exactly right. Regulatory capture is usually discussed in terms of an industry or a set of industry representatives having undue influence over an agency. And I think one of the important steps that Congress took about a decade before the Husherphone case was the passage of the Administrative Procedure Act. In other words, the instruction to agencies like us, all of us, that rulemakings must seek public comment. And of course, the tenet that the D.C. Circuit and other courts enforced that we should make decisions based on that record. Now, there was a time 50 years ago in the world of monopoly telephone regulation where consumers had very, very little say in anything, right? There was one telephone, it was black. But I think it's fair to say, and I think Commissioner Ohlhausen's comments about tweets and social media illustrate this, that the relationship between people and the use of the internet today is not the same. And that's important because what it's done, I think, is to really flesh out the way that the APA is working. So, for example, in the record that's before the Commission on the proceeding that we've been talking a lot about, there were a lot of comments from many people, individual users expressing their desires about how the internet should operate, economists taking us through theory, ISPs explaining the nature of innovation, edge providers talking about risk capital. It's been quite an outpouring of discussion. And it's led to the kind of record that is very diverse and very robust. And so in this respect, I would simply say that the way the technology has evolved and the way people's relationship to it now sits, it has allowed the Commission to get such a diversity of views that the record itself, and not the interests of any particular party, that the record itself will stand as the foundation for whatever judgment the Commission finally makes.
I'd like to give Fiona an opportunity to respond, and then Judge Williams, and then first of the students in the audience start thinking about your questions, please.
I wanted to remind everybody about why we get monopolies, the sources, the different sources of monopoly power. As Commissioner Ohlhausen mentioned, one is government permission. Okay, so we could think about a taxi medallion in that regard, and the great havoc that a company like Uber has played in destroying those monopolies. We could also think about what economists call a natural monopoly, which is when the fixed cost of laying the infrastructure doesn't support more than one firm in the market. So we have a natural gas line that we put down the middle of the street, and it's just not going to give anybody a financial return to dig up the street and put a second natural gas line down the street. And so we regulate the first one so as to avoid monopoly power. And you could think about something similar here with fiber optic cable. Then there's monopoly markets that arise through clever innovation on the part of firms. So a year after the tablet market was invented by Apple, Apple had a 96% market share or something similar to that. And I think there would be few people who would say that that monopoly in the tablet market was a problem. I mean, that market had not existed a year before or 2 years before, and the consumers who bought tablets wanted to buy them, and that was an innovation on the part of the firm. I think that the trouble arises, and we see this in cases like Microsoft and in the discussion today, when the investment that the firm makes in doing something clever and good and useful to people turns into a bridge to a large fraction of GDP. Okay. So if I make an operating system and personal computers take off, and then people start doing a lot of stuff on top of that operating system, suddenly there's a lot of consumer welfare tied up in crossing that bridge. If the fiber optic cable to the home becomes the way that the mother interacts with the child about her student's grade, or somebody figures out who's running for office in their local area or pays their bills, okay, then we have suddenly large fractions of GDP on the other side of that bridge. And I think as a society, then we decide what kind of laws do we have about that. Do we allow the owner of the bridge to control that swath of GDP, or is kind of one of the risks you take when you're an entrepreneur in this country that if you're that successful, maybe somebody's going to come and tell you you can't have a piece of the banking industry because you own a cable. So there, I think, is a social choice problem, but I just want to draw a distinction between that kind of investment that yields a monopoly position and something like inventing the first flying car or whatever it might be.
Judge Williams, did you want to say?
Well, first, thank you, Jonathan, for alluding to the APA. We regard ourselves as its guardians. That said, however, it turns out that most of the cases before us, where some, usually industry group, is one before an agency, the contest comes from another industry group. This is a case where capture is tougher because you have a closer balance of industry groups, and the agencies come out one way or the other, and we, of course, review the statements that have been made under the APA and the agency responses to them to see if they're adequate. Adequate under a very, very forgiving standard. So, and actually, even if you go back to Hushaphone and the MCI cases, those turned on really rather technical notions. There was not the DC Circuit setting itself against a basic policy judgment clearly articulated by the Commission. So we rejoice in, celebrate the APA, but I think there are limits to what we can hope for from it. The bridge metaphor, of course, is a powerful one. I guess what has been missing so far at this conference is stories about how the principles outlined by Mike Powell here 11 years ago, and then effectively adopted by the Commission, don't really pretty much cover the waterfront, as they cover serious hazards. Maybe not, but so far at this conference, there's been no reference to any such episodes. And then going back to what the journalist's favorite friend, the small new innovators. I guess all innovators are new. Anyway, the small innovator. I guess from what I've heard at this conference, I would be much more ready to put faith in David Clark's analysis of what provides them good prospects of access to the ultimate consumers than anything else.
I just want to say one.
So he can't re-articulate his position.
So David said he was going to be here at dinner, and full disclosure, folks, among my clients are Netflix and Google. So I'm just going to say on that, there's a fairly robust debate about whether the transit market, as may have been implied, or you may have inferred from his comments, is an effective constraint. And therefore whether small innovators of the kind that you described would actually...
This is the great danger of speaking about things you don't know anything about.
Well, I mean, I think we all aspire to a permissionless internet, permissionless both from firms with dominant power and from regulators, right? The idea is to let innovators innovate, and the challenge for competition policy is making sure that the market structure is such that the dominant firm can't preclude the innovation through the exercise of market power. So with that, a student, please. May I see a hand? Chris.
So Jean had mentioned earlier on these brown bag lunches between the lawyers and the economists, the FTC and the SEC, and just the idea of that group of people working together to figure out the boundaries of where the FTC should, what the FTC's role is and what the FCC's role is. And you guys haven't really talked about whether or not that sort of thing would be valuable. So I'm wondering if there's more to that aspect of it.
Well, the FTC and the FCC, and for that matter, the FTC and the Department of Justice, have worked together, very well over time. I do think one of the concerns that I have, though, about this reclassification proposal is the impact that it may have on the FTC's authority, because we have an exemption for common carriers. And so it could call into question, make it more difficult for us to do some of the kinds of enforcement that we've done in this area. For example, we're in active litigation with AT&T right now involving their throttling on their broadband, wireless broadband that had been advertised as being all you can eat kinds of service. Unlimited, thank you, unlimited service. We just entered a settlement with TracFone on the same points. So that's an issue that ultimately the FTC and the FCC, if the FCC decides to reclassify, that eventually could be challenged. When the FTC brings an enforcement action, someone can bring that up as a defense, and the court will decide that. So a brown bag between the FTC and the FCC will not settle those kinds of issues. But we do try to work, cooperatively with other agencies. So I certainly think it's always good to try to coordinate as much as possible.
And just one small point, but it is the case, is it not, John, that many of the people who work on competition-related issues at the Commission now have worked in one or the other of the antitrust agencies, and so that helps as a matter of fostering the kind of coordination that Jean was talking about.
Yeah, it's very useful. The two agencies, the FTC and the FCC, have cooperated on a series of enforcement actions recently. There was at least one joint announcement. I think perhaps more than one.
So on the cramming.
Yes, on cramming cases that the two agencies did join, which was very important. And I think sent the right signal to people that the two agencies had a harmonious view about the nature of practices. So that coordination is important and conversation is important, because I do think that the word Jean used, and Jean may want to talk about this from his own experiences at DOJ, is harmonized. In other words, the different agencies, the three agencies we're talking about, all have different statutory grants of authority, but trying to understand issues from a harmonized point of view, it seems to me, is very useful, and we try to do that on a regular basis.
It was an understanding that there was no benefit to inconsistent determinations that would be in conflict with each other. And I think that the piece that jumps out at me is that from an attitude that was not all that positive at the beginning when we started these, there were a lot of good relationships developed, because my experience with the antitrust division is the lawyers and the economists are virtually hardwired to stay in their lane of what antitrust is, for very good reasons, to do their jobs. But they're brilliant, they're creative, and when brought into a discussion of what a sister agency might do under a public interest test or something like that, or in a merger review, there were very vibrant conversations that brought out the skills on both sides, so that it was truly, I think, just an educational experience, and then an ability to understand how you go back into your lane and you look and make sure that you're not doing something that is harmful to each other towards your own goal.
Other questions from the audience? Howard.
I'm glad the mic wasn't on for that. My question is for John and Fiona. I'm trying to get a sense of the limits of each of your arguments. I think when we're dealing with regulating a monopoly, there is large margin for error in still improving welfare. For all the reasons that Fiona pointed out and that Jean Tirole has educated us on, regulation is likely to be very uncertain and not to hit an optimal mark. It's going to hit somewhere in a range. And because monopoly can be quite bad from a price and quality and output standpoint, hitting somewhere in a range is often going to be good enough. So my question for Fiona would be, when we're outside the context of monopoly, but in what the European Commission would call dominance with some level of competition and entry, how strongly would you continue to make your argument and up to what point? And I just want to flip that question a little bit for John. John, you invoked a bunch of values other than typical competition values. Diversity of speech, First Amendment values. To what extent does competition at what point does competition resolve those concerns as well, or is there always a place for regulation in your framework regardless of market structure?
That's a very good question. I think that the nice feature about adding firms to the market so that you have imperfect competition rather than monopoly is that you're helping answer some of those questions that the regulator didn't know the answer to, like costs, technology choices, investment. So even though perhaps the arrival of video at my house is not a perfectly competitive market, I have a couple of options. They have different characteristics. They have different prices. There's some over-the-top offerings now. We can see a landscape that stops any one firm from announcing that the price of serving me is $1 million. Okay? We have evidence that that's not true because other people are in the market. So while it's true that it's harder for the regulator to do better in an imperfectly competitive world, we've already come down a lot from the monopoly price to the place we are, and the regulator's better informed.
John?
Howard, it's a great question, and it's one I've thought for a long time I don't know the answer to. And let me say why, actually. The cases on this that I think come the closest to resolving the question of the Turner Broadcasting cases in the Supreme Court, and particularly Justice Breyer's concurrence in one of those cases, suggests that he offers the possibility, I guess is the way I would say it, that there are some circumstances where questions of free expression might be outcome determinative in and of themselves. That's another way to frame your question. In other words, where would a case be outcome determinative because of free expression and not because it would otherwise be resolved by competition? And Justice Breyer, I think, suggests that there's the possibility for such an outcome. So then one wants to, but the case law and the precedent doesn't really tell us exactly what that is. I think a taxonomy that might be of interest here is to start with the proposition that competition is always the first and best answer, always. And that it may well be that competition answers, by and large, other questions, including non-economic questions. Certainly in a time in the 19th century when there were many newspapers in American cities with very many different points of view, there was not much lack of debate. But a case in which one would want to think about, I think, might be a case in which there was a deeply unpopular form of political speech. Political speech given particular attention under the First Amendment. And the possibility that even in a competitive market, deeply unpopular political speech might not be able to reach intended audiences. So I don't know what the answer would be there. I don't mean to suggest how likely that would be. But I've always thought, as I say, that Justice Breyer's opinion offered some thought that such an instance might in fact exist.
Yes, sir, in the back.
Baron Soka, Tech Freedom. Is this working? So, Gene, a little confused because at your Senate testimony, you dismissed the Federal Trade Commission as a sleepy little agency. That seemed to be your justification for, as Josh Wright put it, the Federal Communications Commission taking away the FTC's jurisdictional lunch money through Title II. And then here today, you're telling us that really at the end of the day, by assessing all these vaguely defined harms about speech and innovation and competition, that the FCC would really be doing something that's just very similar to what the FTC does anyway. But as Commissioner Ohlhausen has pointed out, what you're really describing isn't how the FTC actually works. It's the FTC without any of the constraints of unfairness. In other words, you seem to be really wanting the FCC to do a kind of unfairness minus any cost-benefit analysis, minus any analysis of what consumers themselves can reasonably avoid, leaving only this vague definition of harm. So my question is, isn't what you really want the FTC of the 1970s that used unfairness to regulate everything with no real rigor?
You just told me I didn't want the FTC to do anything. No, I'm not. I'm not. You want me to have you're suggesting I'm asking the FCC to do the equivalent of the 1970s FTC. Is that what you're?
That is my question.
I couldn't tell which agency we're talking about. No, not at all. I'm suggesting that there is a competition analysis, as John Sallet presented, and that there's other values that Congress has demanded that the FCC seek to promote, from universal service and affordability to privacy and to actually expanding competition. Those are clearly different than what either DOJ or the FTC does. And I think it's important to try to connect both antitrust and communications enforcement. I think it's up to the FTC to decide what it wants to do under Section 5, but Commissioner Ohlhausen's comment about policy coherence reminds me of what I see so often. Those who have no power in the political process ask for transparency, because you could at least say process is something, we have a right of that. And minorities in commissions always ask for a consensus so that the majority wouldn't act on its own. But my experience has been that both the majority at the FTC and the majority of the FCC has occasionally acted on 3-2 votes, 4-1 votes, sometimes partisan, sometimes not. So I think that there's really very little difference in the nature of the agencies other than a potential capture problem, which I don't think is as severe as it once was. So I'm just asking them to do their job under the law there. And I'm not asking them to do anything from the 1970s.
Can I make a follow-up to
let me
the questioner's question?
Yes, let me just advise the audience that our referee, following soccer rules, has extended the time for an additional 10 minutes. So we will go until 4:40 and watch the scoreboard. Go ahead, John.
I just wanted to ask, how is there a difference between the FTC operating under an unfairness mandate, which is, unlimited, and the FCC operating under a list, as long as your arm, of good things that it should promote?
Well, I don't know. It's for the FTC to decide. I'd be curious to see how they actually implement it.
But it's not a constraint. It's not a statutory constraint.
Well, it is a statutory constraint, and I would just say my experience with the FCC is pursuant to the APA. They go through a very rigorous process. I saw a commissioner just look at the stack of, I guess, what's being circulated internally and tweeting it out. And my recollection from every other proceeding at the FCC is 95% of that stack is a rendition of the arguments presented by each of the parties before the commission and the commission's reaction to those arguments. So it's a very robust record presented as to how the commission is defining its own statutory authority, and it'll go before the court under the APA. So I have not seen the FTC do that under the little bit of rulemaking authority it has in a very long time.
So
what kind of rulemaking are you talking about?
I don't know. You talked about the little bit of rulemaking.
A little bit of
authority
alphabet
you have.
soup going on here with
That was your term. I don't know what you were referring to. So.
Well, we do have rulemaking authority. We just revised our COPPA rule.
Right.
I mean, we do rulemaking, so.
So for the outsiders looking in, what you're seeing here is the fault of Congress. Because
He's not on the panel to defend himself, right?
right? You've got people in good faith expressing views about agency jurisdiction, and the Justice Department ain't even talking here, right? And the result of it, if you're an innovator, is a little complexity, if not confusion, right? Because you've got so many sources of law, and, not to mention the DC Circuit, right? Where it all may end up. So I think this is an important discussion among the agencies, but just from the outside and looking at innovation policy, one of the things you have to look at is, why is everybody having oar in the water? So there's a question up there, right? I hope that was
Hi, thank you all for being here. My question, I guess, related to Jeff's latest comment. I guess we see in this latest, we don't know what the rules will look like yet, but we see a lot of discussion in this latest round of open internet rules about using Title II and forbearing and using Section 706 and parts of that. And I guess my question for each of you is, do you think that Congress needs to act to create something new for us to work with in this space? And if so, what are a few concrete things or one concrete thing they should do and one concrete thing that they can do right now?
Let's start with Maureen.
I do think it would be a good idea at this point for Congress to step in and to create a legislative framework that clarifies what does Congress think is the appropriate approach, what's the right jurisdiction, what are the values that it's trying to protect. So I think at this point it would make sense. We've had some discussions in Congress. But I also want to mention that I do agree with John on a lot of points, particularly the one that we should always be looking to competition as being the first and best answer to resource allocation in our society. That we have a free market system in the U.S. The free markets we've decided are generally the best way to allocate resources. I think one of the things we need to ask, in whether it's the FCC's approach or something that Congress would do, is will the approach lead to more or less competition in the market to provide broadband? Because ultimately, I think these regulatory approaches are growing out of concerns about whether there's sufficient competition in the market to provide broadband. And I think it's important to think about, well, what we're doing here through whatever route, is that going to increase that market, or is it going to freeze it into place? And so I think that's an important, separate but bigger issue we need to think about.
Well, on the question, I think it's not my place to advise Congress when it wishes to make a law, when it may not. It's obviously Congress's judgment as to whether to revise the laws. I do want to say I think this is a helpful dialogue on the point of competition, because as I said when I described the majority opinion in Verizon, the court went out of its way there to say that, quote, market power, traditional market power, was not necessary, would not be necessary for the commission to have in order to move forward on rules. And it describes, as I tried to recount in some detail, the theory on which commission rules could be based in terms of the ability of ISPs and their incentives. So I think that's useful, because I think it helps to instruct what a conversation can be like about what does it mean to have competition, what does it mean to have policy, to what competition foundations should policy be attached. I think it's helpful.
Did you have a question?
I just have to say, I am an outsider. I'm a lawyer. I'm from Denver. I'm an educator. I'm stunned by, it's the second time I've been to one of these conferences. I needed some CLE. So, that's what
We're glad you're here.
I am stunned by the level of the discourse. I can't follow everything, but I can follow what appears to be a very thoughtful back and forth, including what's obviously the rest of the room with you, and that we're all thinking together about it. I can only share just one thing. I'd like to be able to know that there are times when we govern ourselves in a way that we may make a mistake, but we are trying very hard to reach into the future. and not have a bridge somebody can control. And I've just found this to be an astonishingly amazing discussion today.
Thank you. Thank you.
Thank you.
Yes, sir.
Hard to follow up on that. But going back, sir, thank you very much. Fiona, earlier you said that regulation is ineffective because of asymmetric information, but regulation is ineffective because of asymmetric information, but compared to no regulation, it's preferable. But what about regulation compared to a hard rule? And not to be too topical, there's a historical Title II separation of content from conduit. Which is more pro-competitive, that or an ongoing regulatory regime to ensure that all content providers have fair access?
Let me just clarify that I did not say regulation was ineffective. What I said was that you cannot typically achieve with regulation the perfectly competitive outcome. If the monopoly price is here, you're going to bring it down, but typically not there. Which is more effective, a hard rule or discretion? I think that's, there isn't an answer to that. I'll tell you what it depends on. Partially depends on capture. Do you want to give discretion to your agency? It partially depends on the speed of technical change. If I'm going to have dial-up modems in 1 year and then 25 megabit broadband in a subsequent year, and suddenly everyone's watching TV on that, obviously you've got a big change in the importance of the internet to society and what technologies are available, so you might need to change your rules. And I'm not the lawyer or political scientist in the room, but it's obviously costly to have Congress making new laws all the time. So you might want to give your regulatory agency some discretion. And then, there's the harmonization issue that Jean brought up. If everybody's harmonized and sort of moving down the path together, I think it's less costly to have some discretion.
But what about the business uncertainty?
Right.
You've got to go back to the regulator every time, as opposed to knowing what the rule is and being able to innovate and compete under a clear rule.
So if I can just try to amplify your question, so a clear rule creates kind of an open interface for competition, and a mushy standard may over-deter innovation in your view. That's the question, I think.
Yeah, I think you have to worry that the clear rule deters innovation also. That would be the trade-off. In my time in government, I saw people, firms coming in with regularity and picking up the phone with regularity to find out what different things they were thinking about doing would achieve. I would say, if you're trying to lower price or bring a new innovative product to market or improve quality or enter a new market, it's kind of unlikely that any competition authority is going to have trouble with that. So I guess I think a lot of it seems self-evident to me, what might get you in trouble and what might not. But I think the transparency that John alluded to and the ease of being able to seek guidance from these authorities should go a long way to helping people figure out what to do.
I think you had the next question, sir.
I have no question, but I have three somewhat allied comments. If I heard Judge Williams correctly, he was alluding to the threat of regulatory capture where the regulatees control the regulator. I want to point out that in connection, particularly with the net neutrality matter, that's not what is happening here. This is an agency that has broken free of the influence of very powerful regulatory entities to produce a rule to protect the public. The public is overwhelmingly behind net neutrality regulation. In the city of Boulder, where we are right now, according to one data scraping study, 1 in 80 people participated in this proceeding. That is an unprecedented level of public support for this kind of thing. There is no significant public opposition to net neutrality. There is fierce industry opposition to net neutrality. And Commissioner Ohlhausen, if I understood your comments correctly, you're wanting there to be a very, very broad consensus before the government moves in this case. But the fact is we have powerful entities that are trying to disrupt any possible consensus. And I think that some of the partisanship that we're seeing now is a result of the fact that industry has turned to the Republicans to try, for example, to get the Upton bill and the other bill introduced. Incidentally, no Democrat has signed on. So I don't think we're ever going to get a complete serenity around this issue when there are powerful entities that feel they're adversely affected.
Did you want to respond? You don't have to.
I'm not sure there was a question in that,
right.
so
Thank you.
I don't think I have to respond.
I think
My name was taken in vain.
Mark, you've already had one today. There and then there.
The companies that have been discussed today, kind of in general, would be our Comcast and Netflix, and the conflict and the neutrality and the driving involved in net neutrality. I guess when you think of Comcast, which was an ISP or a deliverer of network delivery company. They purchased NBC. They became a deliverer, a developer, provider of content. So that means that when Netflix and Comcast had a discussion, the competition was not between people on the end. The competition was between two content providers. So my question is, it's more of an historical one. If a company like Netflix decided to buy AT&T, AT&T being a Bell operating company, and coming from all the historical parts, FCC, FTC, all the stuff that's on that, would that be different than when Comcast purchased NBC? I mean, would there be different rules, do you think?
I'm going to let someone else answer that since I represent Netflix currently.
You're right. So you're asking about whether there's different treatment of horizontal mergers between competitors as between vertical? Okay.
100 years of regulation with the Bell operating companies, and whether or not, but there was not the 100 years of regulation with cable providers. So I'm just wondering whether you guys think that there would be something that would be different in that. I'm just kind of wondering, because you guys obviously have a lot of experience with this, with this stuff, and whether or not, in general, the rules would be the same for an RBOC as they were for Comcast, with involving a content provider.
I would say one of the strengths of an antitrust review is it's extremely fact-specific. So it's always going to look at what the particular market is, what the different incentives are, who the customers are, what those relationships are, and then do an antitrust analysis that looks at the likely impact on competition and ultimately consumers, informed by the best evidence and including factual evidence and economic evidence. So, I mean, I hate to say it all depends, but each time, when you look at, like, looking back to the AOL Time Warner merger, right? There were big concerns raised about that. The FTC, ultimately cleared it with some remedies. It didn't end up being the world beater that people thought it was going to be. So it can sometimes, even companies' own predictions don't really play out. But everything is very, very factual and economic specific.
But if I could point out, for the FCC, that's an interesting example where it might be different, because if it's a Bell company, it's a licensed provider of service. If it's
AOL Time Warner said if AOL was buying Time Warner, they had to go through the FCC. Had Time Warner bought AOL, it wouldn't have been overseen.
And Netflix is not a licensee, at least as far as I know right now. So the FCC portion of it could be quite different.
So our referee has come in from the sideline, and let me thank a wonderful panel and the audience for your questions.
So I want to say, like the gentleman here said, it's been a fabulous day of conversations, and tomorrow we'll have the chairs of the two agencies who are really wonderfully represented today speaking here. Now we go to the reception, and this is really important for the students. Can the students all raise their hands? All right, so we've got a good ratio here. I'd love to see as many professionals talking to the students. They've brought a lot to this conference, and Now, please talk amongst yourselves, and we'll see you tomorrow. We start here tomorrow at 9 a.m. Thanks so much, everyone.
Hey, I just needed to tell you why I